Question number two, that is relating to who is a sub-agent, discuss his liability and differentiate between sub-agent and substituted agent. So, Section 191, Section 192 and Section 193 of Indian Contract Act provides regarding sub-agent. So, it deals with the law of sub-agents. The section read as follows: as under Section 191, a sub-agent is a person employed by and acting under the control of the original agent in the business of agency, and as regarding the very sub-agent representation of principal by the subject sub-agent properly appointed. Where sub-agent is properly appointed, the principal is so far as regards third person represented by the sub-agent is bound by and responsible for his acts as if he were an agent originally appointed by the principal. So, agent's responsibility for sub-agent, the agent is responsible to the principal for the acts of sub-agent, and sub-agent's responsibility. The sub-agent is responsible for his act to the agents, but not to the principal, except in case of fraud or willful wrong, as it is provided under Section 192 of the Contract Act. So, where the goods were agreed to be carried by A, and A is asked B to carry the goods, it was held that A was liable even though it was proved that B was the carrier and not A, as it was decided in the leading case Saha Jugal Das Amrit Lal versus Saha Harilal and others in 1986 by the Gujarat High Court. So, agents' responsibility for sub-agent appointed without authority. So, regarding that, where an agent without having authority to do so has appointed a person to act as a sub-agent, the agent stands towards such person in the relation of a principal to an agent is responsible for his acts both to the principal and to the third person. The principal is not represented by or responsible for the acts of the person so employed, represented by or responsible for the acts of the person so employed, nor is that person responsible to the principal as provided under Section 193 of the Contract Act. So, lastly, the relation of the principal and the sub-agent. So, the relation of the sub-agent to the principal are dependent on the question whether the agent had an authority to appoint the sub-agent and whether the sub-agent has been properly appointed. Where a sub-agent is properly appointed, the principal is super as regards third persons represented by the sub-agent and is bound by and responsible for his acts as if he were an agent originally appointed by the principal. In brief, when the employment of a sub-agent is valid and legal, the principal is bound by and responsible for his acts. So, the liability of sub-agent as provided and as under section 192 of the Contract Act, and in connection to that we will discuss the very leading case which relates to that defined exactly the very liability of sub agent, and in regards to that we will discuss the leading case Nimsuk versus Bridichan by the Bombay High Court. So, in that leading case, the very outcome or the bells of cotton a consigned to be in Bombay for sale on commission and be advanced against the bells certain percent of the market value of the goods. The railway receipts were handed over by B to a firm of Mogdoma, who took delivery of the bells and stored them in their godown. The Mogdomas were employed by B and their charges were first paid by B and then debited by B to the account of A. Their duties were to store, sell, and give delivery of the bells. The Mogdoma fraudulently disposed of the bells after being authorized by B to sell them and became insolvent. The Bombay High Court held that the Mogdomas were sub-agents of B, and because they had committed a fraud in the course of employment which was authorized by B, so B was liable to make good the loss to A. And now we'll discuss what is a substituted agent. A substituted agent is a person who has been selected by the agent who holds an express or implied authority to name another person to act for the principal in the business of agency, and show the very distinction between sub-agent and substitute agent, as both in the case of sub-agent and a substitute agent, the appointment is by the agent, but there is a marked difference between the two in this respect, that in the case of sub-agent he acts under the control of and the directions of the agent, while in case of a substituted agent he is an agent of the principal and is bound to act under his control and direction. And in the case of a substitute agent, there is a direct privity of contract between him and the principal, which does not exist between a sub agent and the principal. Thus, the distinction between a sub-agent and a substituted agent can be summarized as the employment by the agent of a sub-agent does not normally bring into being any privity of a contract between the principal and the sub-agent. In case of a substitute agent, the original agent names the person he appoints to present the principal. The naming should be to be the principal himself so as to bring about privity of contract between them. And the second difference we found, the sub-agent is responsible to the agent alone and cannot be sued directly by the principal. But a substitute agent is responsible to the principal and not to the original agent who appointed him. Therefore, a principal can sue him directly. And the third difference we found, the agent is responsible to the principal for acts of the sub-agent, but a substituted agent is directly responsible to the principal. So, these are the basic differences that we found in between sub-agent and substituted agents. So, hereby we complete the appropriate answer to question number 2 in relation to contract of agency, and in our next upcoming video we will discuss question number 3 in relation to contract of agency, and that is describes the different modes of creation of an agency as provided under section 186 and section 187 of the Indian Contract Act.